Back to the channel, legalizers. If you're new here, this is the place where we break down everything happening in the cannabis industry: legalization, legislation, business, and some legal battles shaping the future of the plant. Like this one on legislating from the bench and hemp. If it's your first time watching, make sure to hit that subscribe button and tap the bell so you don't miss out on any updates. And if you're into deep dives on legal and industrial topics like this, drop us a comment below. We would love to hear your thoughts. Today, we're delving into two important cases and how they're stretching the 2018 Farm Bill to its breaking point. These cases involve Delta-8 THC and THCO acetate, both synthetically derived cannabinoids being called legal hemp. But are they? And how would Justice Antonin Scalia, one of the greatest legal minds of our time, approach these decisions? Stick around, because we're going to look at the Farm Bill, these courts' rulings, and how these cases provide a perfect example of why judicial overreach can lead to absurd and even dangerous outcomes. By the end, you'll understand not only these rulings, but why words matter so much in law, and how Congress may fix this in the next Farm Bill or the budget when Republicans take back the Hill in 2025. But let's go back in time to review what the Farm Bill says in 2018. That is the law that legalized hemp. Its definition of hemp says the plant, Cannabis sativa L, and any part of that plant, including the seeds thereof and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta-9 THC concentration of not more than 0.3% on a dry weight basis. At first glance, this sounds pretty simple. Congress wanted to distinguish hemp, non-intoxicating crop used for industrial and medical purposes, from marijuana, which contains higher levels of delta-9 THC. The bill legalized not just the hemp plant, but also its natural byproducts, like CBD oils or fibers, so long as they meet the THC limit. It was so low to keep you from getting high. The controversy starts with the words all derivatives. Courts have interpreted this phrase to mean not just naturally extracted substances, but also synthetic products, things created through chemical processors that never occur naturally in the plant. Is that what Congress intended? Let's ask, what does the word derivative actually mean? Let's get our dictionaries out. This is where Justice Antonin Scalia's textualist approach shines. Scalia believes in sticking to the plain meaning of the words in the law, and he often turns to dictionaries to understand them. According to Merriam-Webster's, a derivative is something that is derived, specifically a substance that can be made from another substance. Notice, what does this definition suggest? A derivative is directly made from the base material. It is not inherently, or does not say in the law, synthetic, things that are chemically transformed into something entirely new. If Congress had wanted to legalize synthetic derivatives, it would have said so explicitly. Now, how do courts decide that these synthetic or semi-synthetic cannabinoids like Delta-8 THC and THCO fall under the Farm Bill? Let's go over it and talk about judicial overreach, aka legislating from the bench. Justice Scalia often warned against this legislation from the bench. This is what happens when judges go beyond interpreting what the law says and instead insert their own ideas or preferences into the law. In the context of hemp's definition under the Farm Bill, courts have taken the phrase all derivatives and stretched it to include substances like Delta-8 THC and THCO, which are chemically transformed in a lab. These cannabinoids don't occur naturally, not even Delta-8. If you have any dispute on this, you can read the final rule published by the USDA in 2021, where it explained that the reason why Delta-8 THC was not included in the definition of total THC is because it happens in such trace amounts in the plant that the devices they use to test the concentration of THC could not detect it. Therefore, it has to be synthesized from CBD or Delta-9 THC. By broadening the meaning of derivatives, the courts have essentially rewritten the law to include synthetic products. Congress never mentioned this. This is judicial activism, plain and simple. It's not the role of the judiciary. What happens when courts interpret laws too broadly? In the next segment, we'll look at two cases, one from the Ninth Circuit and one from the Fourth Circuit, where this judicial overreach played out. These cases show why words in the laws matter and why Scalia's approach of originalism and textualism is more relevant than ever. Now that we've set the stage, let's look at how the courts are applying the Farm Bill in ways that Justice Scalia would be rolling over in his grave if he found out about it. The Ninth Circuit and the Fourth Circuit cases involving Delta-8, THC, and THCO acetate are perfect examples of how broad interpretation of simple words can lead to absurd or dangerous results. The Ninth Circuit and the Delta-8 THC case. It's the AK Futures versus Boyd Street Distro LLC. This case dealt with a synthetic cannabinoid called Delta-8 THC. Delta-8 is created chemically by altering CBD, which is naturally found in hemp, into a psychoactive compound that barely occurs in hemp. The court ruled that Delta-8 THC is legal under the Farm Bill because it originates from hemp CBD. In other words, the court said that because the starting material came from hemp, the final product, a synthetic compound, qualifies as a hemp derivative. This ruling effectively added the word synthetic to the Farm Bill, something Congress didn't write into law. Justice Scalia would have said that this is judicial overreach. He might have said the statute does not include synthetic cannabinoids and courts have no business inserting them under the guise of interpretation. Now we'll move to the Fourth Circuit and THCO acetate. This is the Anderson v. Diamond Investment Group LLC case that was decided by the Fourth Circuit in September of 2024. And it deals, of course, with THCO acetate, a synthetic cannabinoid made by chemically altering other cannabinoids. It does not exist naturally in hemp. It's entirely a laboratory creation. The court, however, ruled that THCO qualifies as legal under the 2018 Farm Bill. The judge argued that the Farm Bill's inclusions of all derivatives meant any product synthesized from hemp, including THCO, could be classified as hemp as long as it contained less than 0.3% Delta-9 THC. Scalia would have said this is a classic example of judicial overreach. The word derivatives refers to substances that are naturally extracted or derived directly from hemp, not synthetic compounds that are chemically transformed into entirely new substances. The judiciary has no authority to add words like synthetic derivatives where Congress did not include them. But the Fourth Circuit went even further. And this is a footnote that was pretty interesting. The court criticized the recent Supreme Court decision overturning the longstanding Chevron doctrine, a doctrine that required courts to defer to agencies like the DEA when statutory language was ambiguous regarding what its experts believed. The Fourth Circuit made it clear that they were applying their own interpretation of the Farm Bill without relying on DEA expertise. This creates a troubling precedent. By discarding the DEA's position that THCO is a Schedule I controlled substance, the court opened the door for synthetic cannabinoids to proliferate without adequate regulation. Justice Scalia likely would have chided this as a dangerous departure from common sense and legislative intent. Courts are meant to interpret the law, not substitute their judgment for Congress or federal agencies. And that is the absurd result of THCO being called hemp. And there's also public safety risks. Let's consider another absurd result. This is the same reasoning, and it could also be considered hemp by the precedent of AK Futures and the Anderson case from the Fourth Circuit. A key ingredient in dynamite is called nitroglycerin. It could be a hemp derivative. Nitrocellulose from the hemp plant can be chemically synthesized into nitroglycerin. Does that mean that dynamite made from hemp cellulose is legal? Of course not. But the logic of the rulings clearly doesn't prevent it. The same goes for synthetic drugs like K2 or spice, taken from the hemp plant and concocted in a laboratory to add additional chemicals and make them. That could be argued to be also hemp under these new legal precedents interpreting a word that is not found in the actual congressionally defined term of hemp. This isn't what Congress intended, and it's a public safety disaster waiting to happen. So how would Justice Scalia handle these cases if they hit the Supreme Court when he was still on the bench? Well, let's take a closer look at his approach. Justice Scalia likely would have approached these cases with one simple question. What does the law actually say? He'd go back to the text of the Farm Bill and the dictionary definitions of the words Congress used. Based on this, Scalia likely would have concluded that the term derivative refers to natural substances extracted from hemp, like CBD oil or hemp seed protein isolate, not synthetic products made in the lab from CBD oil or nitrocellulose. He'd also emphasize judicial restraint. Courts are not legislatures. If Congress did not explicitly include synthetic cannabinoids or other chemically altered substances in the Farm Bill, it's not the role of the judiciary to add them. So how do we go ahead and fix this problem? To prevent these kinds of misinterpretations, Congress will be updating the Farm Bill, and we know that that is coming soon because both the House and the Senate have released their versions of the Farm Bill. And the Senate version, which was currently under the Democrats, probably is going to change once the Republicans take the majority in January. Not only that, in their budget, they also have adopted language that would close this loophole so that hemp is hemp. It's not nitroglycerin or synthetic drugs. And go further to exclude these semi-synthetics or synthetics from the definition entirely. The next Farm Bill presents an opportunity for the new 2025 conservative Congress to step in and restore the law's original intent. This isn't about partisan squabbling over unrelated issues like SNAP benefits. It's about protecting public safety, closing dangerous loopholes, and ensuring that laws are interpreted as they were written. The Farm Bill was never meant to legalize semi-synthetic cannabinoids or dangerous substances. It was intended to regulate natural hemp and its derivatives that directly come from it. But when the courts stretch the law, they create confusion and unintended consequences. Original textualists like Justice Scalia showed us the importance of sticking to the plain meaning of the original text of the law. Now it's up to Congress to fix these issues. Alrighty, legalizers, that's a wrap on today's deep dive on legislating from the bench and the 2018 Farm Bill definition of hemp. That has been judicially amended to include cannabinoids synthetically made from its natural derivative, CBD oil. If you found this video useful, hit that like button. It really helps us get the word out to more people just like you. And don't forget to subscribe and turn on the bell so that you will not miss a future video. Also, we want to hear from you. Drop us a comment and tell us what you think. Do you agree that courts are legislating from the bench here? How do you think Congress should fix the Farm Bill loophole? Or do you think that they don't need to be fixed at all? Thanks for watching, legalizers. Until next time, stay informed, stay empowered, and let's keep building a smarter cannabis industry together.